and Senator Shireen Golden Campbell. So we have a robust quorum this morning. We have some visitors that we will recognize and welcome shortly. But just to let you know did we get any formal apologies? No formal apologies. Of course, we're going to do the minutes and matters rising from the minutes. And then the substantive business today is the review of the matrix of submission on the Act. We have what I call the mother document, that is a recording of all the submissions by Jamaica Bar Association, Bank of Jamaica, all the other bodies that submitted to us in the document that is from the Parliament. And then the matrix is prepared by our Minister of Industry, Investment and Commerce and the Company Office of Jamaica and other agencies. This morning we're going to be led through the matrix by Miss Shelley Leon, who's the head of the Company Office of Jamaica. She's the CEO. But before we do that, we're very privileged this morning to have 73 students and 5 teachers from the Catherine Hall Primary and Special Education School. And we're just so happy to have you all here. Saw your wonderful big bus outside that brought you here. Glad to see that the driver was very careful. This is your House of Parliament. In fact, so much more than ours, since you have so many more years to live than most of us in here have left. So we were really very happy to welcome you all of you, from the Catherine Hall Primary and Special Education School, the 5 teachers who have accompanied them, and to say to you that as often as you want to learn about government, you say to teacher, especially on a day that you think you would rather not be in school, say, teacher, we really should go to Parliament and see what's going on down there again. So come here as often as you can. We welcome you, we're happy to have you, and we want you to recognize that this is a very important part of your life. Don't let anybody tell you that, oh, politicians don't do anything. Politicians make laws that affect every area of your life. Which food you buy, because, for instance, in my ministry, there's a Bureau of Standards that must judge and assess they test all the food that you have. Then the NCRA, another agency, goes and it tests in the field that the people who sell you the food, the rice, the flour, and so on, are not selling you things with weevil and all kinds of additions in there that you shouldn't be eating. And government makes rules about the tests that you get in hospitals and from labs. Government makes laws about which side of the street you can walk, you should drive on when you drive with your parents or the bus driver, and how you should cross the street. Almost every aspect of your life, something is affected by what the government does, and what the government does is done and recorded and made official in this house called the Houses of Parliament, Gordon House in Jamaica, your house. So I hope you understand how happy I am to welcome you all to your house, and keep learning. Every time it slips, you say, teacher, what else they're doing in the Parliament? And let the teacher go on site and say, oh, the agenda for this week in Parliament is such and such, and it's published. So keep abreast, and maybe one of you in there, 5 of you in there might become MPs or senators, and who knows, there might even be a prime minister in your group. So welcome to your Parliament. The minutes have been circulated. We're going to take them as read, as we welcome to the people from various areas, from, of course, my ministry, from the CP, OPC. That's the Office of the Parliamentary Council, so to make sure that we don't use these acronyms those people you see up there, they're lawyers, whole heap of lawyers in this business. And they come from the Office of the Parliamentary Council. What do? They look at the legislation, draft it, make sure when we make amendments, they fix it again, and come back so the laws can be as good as we can possibly make it until they have to be amended again. So that's what they do, and the people in front here, the lady opening a file there to my far left is Miss Shelley Leon from the Companies Office of Jamaica. They register all the companies in Jamaica, again, government affecting all aspects of your life. And Mrs. Sutherland Reed and her colleague are from the Ministry of Industry, Investment and Commerce, the ministry that we now call Jamaica's Business Ministry, and the ministry for which I'm the minister. So we're about to start, and the minutes we will take as read. Any comments or corrections from members of the JSC for the minutes? None. Then I'm going to ask Senator Longmore if she would move, and wonder if Member Robinson would second it for us.
Yes, second.
Thank you very much, Member. Any matters arising, please? No matters arising. So we go to the main business, and that's the review of the matrix of submission on the Act. And Ms. Shelley Leon will lead us through that exercise. And I know, just like the other matrices that we've used, we will be very efficient about it. And you now have the floor, Ms. Leon. Turn on if you press the middle part. Yes, now you're on, Mike.
All right, good morning. All right, so what I propose to do this morning, and I crave your indulgence, so I want to go from the specific to the general, dealing with the recommendations per organization. And I will direct you to the page in the main matrix that you would have received, which deals with the specific recommendations. So firstly, we want to look at the Jamaica Cooperative Credit Union League, and those specific recommendations can be found on page 10 of the general matrix.
Page 10, you said?
Yes, Mr. Chair, page 10.
Of the basic document, okay.
Yes.
The mothership, all right.
Mm-hmm.
And yes, we're there. And what are we talking about?
All right, so the first recommendation from the Credit Union League, which was already proposed by the MIC, is to amend the definition of account debtor. And this amendment is intended to provide clarity. So we're now distinguishing debtor from account debtor, and we have done that specifically to ensure that intangibles are incorporated under SIPA. The second recommendation Mr. Chair,
could you be a little bit clearer as to
okay.
why you're separating account debtor from debt, from account, or whatever you're separating, and make it clear, a little clearer for us. But Senator Longmore has a query. You want to press your mic so that it can be recorded?
So just a little clarity. I see this document here, which is also from the credit union. So is it that this has been incorporated in the main matrix?
It has.
Okay, all right, thank you.
Yes, the big flat one with the small writing has everything. That's a mother document. And everything from
Yes.
credit union or bar association, everything is in the flat document.
Yes. All right. So it had long been observed that under SIPA, it takes account of various types of personal property. One form of personal property that is considered is intangibles. And included in the intangibles is, for example, accounts receivables. But the definition as put forward only referred to as a debtor. So we now want to include account debtor to make it clear that intangibles and such as accounts receivables are being accounted for when we are referring to debtor.
All right. Number 2.
The second recommendation is to include a definition of document in title. And this was also previously proposed by MIC. So currently, there is no definition of document of title, although the term is used throughout the Act.
So now you're defining it.
So now it is being defined.
All right.
Thank you.
Thank you. I believe the recommendation should be to relocate. There's a definition of negotiable document of title in section 33, which is pretty much the same as the definition that is now being recommended to be inserted. So I think the recommendation should be to relocate that definition to section 2, so it covers the term where it's used generally.
So we lift 32 and make it number 2.
Right, 33.
33, because 33 really covers what number 2 is recommending. You have that, Ms. Sutherland? And you agree with that?
Yes, we agree with that.
Okay. Move on.
The next recommendation is to amend the definition of security interest.
Okay.
So, and this too was already proposed by MIC. So the Act provision on attachment, perfection, and priority do not apply to transactions covered by the proposed amendments. So the amendments seek to cover consignments. It should be noted that the current provision on consignments are ambiguous, as it is unclear whether the provisions on attachment, perfection, priority, and enforcement apply to consignments. And in relation to leases, the definition of security interest includes leases that secure payment or performance of an obligation, but not leases for more than 6 months that do not secure payment or performance of an obligation. Additionally, it is necessary that the provisions of the Act should contemplate and include accounts receivables. Therefore, where the term security interest is used in the Act, account receivables would be included. So the new definition, therefore, would refer to the accounts receivables, the consignments, and the leases for a term of more than 6 months. because these are areas where questions had been raised previously. So the definition now expressly speaks to them so that there will be no ambiguity.
OPC?
I'm a little unclear as to the amendment being recommended because the definition of security interest is right now very general. It speaks about an interest created contractually over one or more items of personal property, whether specifically or generically described present or future, and securing the fulfillment of one or more present or future obligations. So it doesn't include or exclude any particular item of personal property specifically. Where we come to the application provision in section 3, it does, it's also in very general terms, and it does expressly say without limiting the generality of the foregoing, and then it goes on to list certain things which do, for the avoidance of doubt, are included in the term security interest. There are specific exclusions in subsection 2 of section 3 that state what the act does not apply to. So if there's some doubt, maybe it would be section 3 that should be amended to clarify what the act does or does not apply to. So, for example, if there's some doubt about consignments or the types of leases, you could amend section 3 to clarify there, but I'm not seeing where an amendment to the definition of security interest would be warranted.
All right, so we do agree, that the definition as presented, it is general and it can include a wide range of personal property. However, after local and international consultations, so coming from the persons in the private sector, the users, and international consultants, we have received on several occasions this very same recommendation, as it has been indicated that there may be some ambiguity, and that when you look at legislation elsewhere, these items tend to be specifically referenced. So as early as the Cohen report and coming as well from several of the stakeholders who reviewed the legislation, they thought that it would provide more clarity, and ease of use if we did specifically mention and include these areas.
Is that you're in agreement now and that can be arranged the way that?
So,
sounds like you agree, but let me ask my members. Members, any comment on this item? No comment? Continue. Which document are you referring us to now?
all right, so I am still on the Jamaica Cooperative Credit Union League specific recommendations, which that still starts on the page 10. So I'm continuing with their recommendations, which those repeat a lot of what had previously been recommended by MIIC, but since we're going through all of the individual recommendations, we're just repeating them. All right, so the next recommendation is in regard to serial numbered property. So it has been recommended that we amend the definition of serial numbered property, which will result in a more expansive definition.
You're still on page 10 of the big document, or you've gone to a different document?
It's now page 12 on
right.
the
So
main matrix.
as you move, you have to tell us where you move to.
Okay.
Okay? Okay. go
So the definition as presented, it was previously limited, and now it is recognized that there are several items of personal property which could have a serial number, and so this general definition should be included. So it will include other types of movable property, such as boats, aircrafts, etc.
All right. Any comments? No comments. We keep going.
The other recommendation is to, in regard to Section 5, attachment of security interests, to delete subsection 3 to 6 from Section 5 because they were not appropriately placed there, and insert them as a new provision entitled modification or substitution for a security contract. And that is on page 14 of the general matrix, or the basic matrix. So the marginal note for Section 5 is attachment of security interests, but subsection 3 to 6, they do not relate to that specific issue, hence the recommendation made. Can we now move on, Mr. Chair?
Yes, please. Senator Longmore has a comment.
If I might just go back a bit to the recommendation 4 with the serial numbered property.
Right.
And it says vehicle, equipment, machinery, aircraft, etc. Would you consider a cutoff at a valuation of said machinery, equipment, etc.? So, all right, let's say a generator. You have generators of varying sizes, etc. Is it that versus, I mean, for the micro businesses, an item that is of relatively less value? Would the requirement for the serial number be also applicable for that lesser value? So whatever equipment?
Yeah, anything that has serial number, because as is, currently it was basically restricting it to motor vehicles rather.
Right.
But we have a wide range of personal property with serial numbers. So whether high in value or low in value, in order to support being able to properly identify the property, because as you know, that's one of the general comments often made, that with personal property, it's difficult to identify them. So we just want to provide every opportunity to provide a descriptor, which is objective and universal. So as long as it has a serial number, then you would be able to.
And that's something like a weed whacker would probably have that too.
Quite correct.
Right. Yeah.
Quite
Okay.
correct. So it would really help us
Yes.
in saying this is the property that we're referring to.
Right. So
Yes.
again, public education is really very critical
Yes,
because I
yes.
think even for the individuals who have such possessions to know the potential that this
Right.
could
So that
become
they
significant
ensure that
equity.
they preserve those marks.
Right.
You're quite correct.
So we need to, yeah.
When we get to the general comments, we will indicate what we intend to do in regard to those matters like public education,
Right.
etc.
Yeah.
Yes.
All right. Thank you. Thank you, Chair.
Mr. Chair,
Yes, please.
I am very happy for that question that Senator Longmore has asked because
I don't see who is speaking online. Who is it? Professor Morris. Thank you, Prof. Go ahead, please.
I was saying that I'm very happy for that question that Senator Longmore asked because it gives me some clarity on the serial number issue. Because what in the context of a person with a disability who would want to use, for example, a Braille machine, all Braille machines would have a descriptor and it would have the serial number. So a braille machine could be used in this context. Right, Madam?
That is quite correct. A machine such as that, a computer, and several other such items.
Moving
Thank
along.
you. Thank you.
All right, so still on page 14 of the basic/general matrix, the next recommendation is in regard to section 8, effect of perfecting a security interest. This is on page 15, sorry. This was also previously proposed by MIIC, and the amendment will recognize that a right conferred by a security interest which is not perfected as provided by section 8 and 9 shall not be perfected against third parties, whilst recognizing that exemptions exist under the Act, or rather exceptions. Additionally, the marginal note for section 8 is effect of perfecting a security interest, but subsection 6 is dealing with disposal. Therefore, the suggested amendment will address the misplaced provision. So in other words, we will remove subsection 6. We propose to move it because it does not belong in section 8. And in addition to that, we propose to make a change which makes it clear that where the security interest is not perfected as set out in sections 8 and 9, that would not be enforceable against third parties. So whereas it would be enforceable against the debtor, and this is what we're making clear, it would not be enforceable against a third party.
Any comments? No comments? Move. Oh, right. OPC has a comment.
Yes, we are not necessarily in agreement with the rephrasing of subsection 1. It's expressing the provision in the negative. It is really saying when you can't enforce the security interest. But then by removing the provision as is, you are also removing the statement or the right, giving the person the provision giving the person the right to enforce the security interest.
So you're going to put it in the positive for us?
I would think the provision as it is now captures both positive and negative. Okay. Otherwise, we don't have any objection to including the words unless otherwise provided by this Act.
So we yield to the drafters once it reflects the objectives, the desired objectives, so to speak, which is that persons using the legislation should be aware when failing to perfect will impact the debtor or the third party, that distinction.
Okay, OPC. Ms. Grant, you're mollified or you're still mulling?
I'm still not sold on these words, but I suppose the recommendation could be to rephrase it to capture both. Mm-hmm.
That is what is intended. So we'll yield to you to draft as you see fitting to capture that, to better capture what is intended.
So the principle is agreed. The wording will be drafted.
Thank you, Mr. Chair.
Thank you, Ms. Grant. Moving on.
The next amendment, proposed amendment, is in regard to Section 11, dealing and proceeds, and that is on page 16 of the basic/general matrix.
All right, we have that. Go ahead.
And it is proposed that section 11 be amended so that there is an avoidance of...
That's 11.1.
That's correct, section 11.1.
Okay.
So that there is avoidance of ambiguity and confusion. Section 11 addresses when a security interest continues after transfer of the secured property. The exceptions to this provision are provided in Part 4 of the Act. Therefore, the reference to Part 4 is necessary to provide for these exceptions. So the two will be linked, so it will be clear that except in what is applicable in Part 4, this is how we would treat with security interests where that continues after the property has been transferred. So, for example, a secured creditor has an interest in a piece of equipment, and after the debtor, or not the debtor, after someone purchases that equipment, the security interest in the equipment continues. So this section addresses that kind of scenario. So in regard to dealings with proceeds and after acquired property, etc. So even though the item is sold, the security interest continues, even though it is transferred to somebody else, with the permission of the creditor.
Right, the creditor has to agree, because the creditor has an interest.
Has the interest, correct.
You know, go ahead. No, go ahead, Sam.
So for us, not as the financial gymnastics, so that allows for quite a lot of flexibility and almost an equity share, if we could reframe it.
There's an interest. We would not say an equity share because that moves to ownership.
Okay.
And interest is not the same thing as
Right.
ownership. So we will stay with interest. Now, of course, OPC is right over there to correct me when I cross the line. So, but I think I'm
just trying to break it down.
Yes.
But that does allow for quite a bit of flexibility for the owner.
In fact, Senator Longmore, this is a good place for me to pause and say to our visitors from, the Catherine Hall Primary and Special Education School and the teachers, what is going on here is how we make a law. So which law are we looking at? Let's say mommy and daddy, or mommy owns a washing machine. She owns it. She's paid for it. But now your older brother or sister needs a laptop, and you need a tablet, and mommy probably needs a new cell phone to keep in contact with all of you. She goes to a place that sells those things. And she said, look, I have my washing machine. I own it. I will give you my washing machine as security to buy a laptop, a tablet, and a phone for myself and my children. Why she has to do that? Because the person who is selling the laptop and the tablet and the phone want to have something as security that, mommy and daddy will have a real interest in paying off for those tablets. And so we're making a law that allows the washing machine, or it might be a blender, or something else that mommy owns, to be used as what we call security for a new piece of equipment or device that she might need for the family or for you to use. That is what is going on here, but it sounds difficult and cumbersome and all kinds of minute, and they want a word change. Those people from OPC, they love to change words and add new words in there. But we all have to do this to make sure the law is right. So we're glad you're here this morning to see the process that lawmakers have to go through to make laws that will make the running of our society better. If you don't have laws, you have chaos. So we're trying to make sure we put a measure of order while leaving you with a great deal of freedom as we make these laws. So that's what we're doing. Back to you, Ms. Leon.
Yes, and then in regard to this particular provision as well, which will be important, you'll understand even better this recommendation when we go to some other recommendations later. So as you were explaining, for example, here, if you have a financial institution that had loaned money for a motor vehicle and the person who borrowed it sold the motor vehicle, this indicates without permission, the security interest would continue, and it continues to the proceeds that you got from the motor vehicle as well. Right.
But there probably will be a lawsuit coming out of that.
Yes, most naturally.
Because you sold an asset in which I have a keen interest, a registered interest,
yes.
And you have broken effectively the law.
And
continue, please.
Related to that as well, no, I did that. No, so we're now at 16. Related to that as well, the next amendment.
We're still on page 16?
Page 18.
Okay.
We're now on page 18, which we're dealing with the recommendation to 16A, which is agreed disposal free of encumbrance. So we're suggesting the insertion of a new 16A,
right,
which indicates the secured creditor may, in accordance with the terms of the security contract, authorize the debtor to dispose of the secured property free from encumbrance. So the suggested amendments will make it clear as it removes a misplaced provision from Section 8. And the proposed section will deal with agreed disposals free of encumbrance. Now, this is very important as well. So there are, for example, some persons who are a bit reluctant to step away from the whole concept of floating charges, which, for example, large motor vehicle dealerships, they may use this where they borrow money, purchase a number of motor vehicles. The motor vehicles are disposed of free from encumbrance. What is clear here is that under SIPA, with this definition of security interest, you can still do such transactions. All that needs to happen is the secured creditor merely has to agree that you can dispose of the asset free of the security interest. So those kind of transactions wherein you're buying goods, you're using monies that you borrowed, but you dispose of it without a lien on it, it can still very well continue once it is agreed.
Any comments? Sounds clear to me. No comments? Moving along, please. Keep us noted on the page.
All right. The next proposed amendment, it is on page 19 of the basic/general matrix in regard to section 18. Consumer goods.
Page what are you on, sorry?
19.
Okay.
So currently, the provision that is that if in a sale or lease, the total value of the good exceeds $10,000, then the buyer or lessee takes the good free of the security interest. The proposal is that this amount of $10,000 be increased as based on the time value of money. So where we were in 2014, in 2024, 10 years down the line, that value would seem too negligible. So it is proposed that this be increased to $25,000.
All right. Any comment on the value? Now, when we set values like this, they become outdated in 3, 4, 5 years. OPC, Ms. Grant, how do you word this so that it's not, it's inflation? How do you do this?
Subsection 3, sorry, the current subsection 2 would address it because there's a power given to the minister by order to increase the amount.
You know, that's exactly what I was looking for.
Mm-hmm.
Properly well done, given to the minister. Thank you, that answers that query. Any comments from my colleagues? None. Continue, Ms. Leon, if you will.
All right, the next proposed amendment, which is on page 19 of the basic/general matrix, is in regard to section 19 of SIPA. The proposal is to delete subsection 2 of section 19 and renumber the present subsection 3 as subsection 2. This section does not apply to motor vehicles held as inventory by dealer of motor vehicles and sold in the ordinary course of business. So the current section 19.2 provides an explanation of the term serial number with reference to a motor vehicle. So the deletion of the provision supports the expansion of section 19 to address serial numbered property. So the restrictive term specifically being linked to motor vehicles is being removed for the more general applicability of serial numbered property. Mm-hmm.
Ms. Grant?
I'm suggesting that it's not incompatible, even with the expansion, for us to retain the definition of serial number with reference to a motor vehicle, because even if the provision is expanded to include other items, this would still assist you in identifying what is meant by the serial number in relation to.
So just broaden it. Don't
but
make
you
it
could
narrow.
keep
Good.
two.
Yes, right. Okay, that sounds good.
Okay.
The same thing. Yes. Okay. Go ahead, please.
All right, the other proposed amendment is in regard to section 32, execution creditors. And this is on page 22 of the basic/general matrix. Page 22. So we propose to amend subsection 1 of section 32 to make it clear that there are exceptions to the execution creditor's priority. For example, under the Act, perfected purchase money security interest have a super priority over the rights of the execution creditors to the property. In respect of the new subsection 3, these provisions, they are intended to ensure consistency with Section 85 of the Insolvency Act. So if a security interest exists, but it's not perfected at the date of bankruptcy, the security interest will be treated as unsecured debt. This means that the creditor will hold the security interest and that person will not have priority over unsecured creditors. Therefore, if the trustee files a notice promptly, the Act ensures that the unperfected security interests do not unfairly impact the distribution of assets. So basically this legislation, we want to correlate it to the Insolvency Act. So as far as the execution creditor is concerned, we're bringing clarity to the rights of the execution creditor, making it clear that So the execution creditor, for example, may be someone who receives a judgment order from the court. So we are making it clear that if the point in time that they got this judgment will determine whether or not their priority can trump someone who, under the Insolvency Act, basically. So it is aimed to make clear the priority of an execution creditor where there is, for example, insolvency in the company.
No comments? Moving along. On page.
So the next section for the proposed amendment is section 33, and this is on page 23 of the general/basic matrix. And
We are amending.
we are amending subsection 1 of section 33. And the reason that we want to do this
Not 32.3?
33.1.
33 at the bottom. Okay. Got it. Yeah.
The section is being amended by creating an exception to Part 6, enforcement of security interest, to certain types of transaction, including sales of accounts receivables and commercial consignments that do not secure payment or performance of an obligation. So these exclusions are necessary as the seller and the consignor have title to the receivables sold or the goods consigned. As such, the buyer and the consignor should be entitled to retain the proceeds of any disposition of the secured property. So in other words, we do not want to make any enforcement any more difficult than it needs to be. So for example, in the case of the consignment and in the case of the receivables, where the persons, they may simply sell items or dispose of an account receivable. They don't have to go through the cumbersome process. They are entitled to keep the proceeds that they get after, for example, they dispose of that account receivable. The secured creditor. So we want this regime to be attractive. We're seeking to promote access to credit, to encourage participants to want to be a part of this regime. We also have to ensure that for secured creditors, we don't subject them to unnecessary hurdles, so to speak.
Any comments? No comments? We move on.
The next proposed amendment is to section 35 of the Act, and this is on page 25.
Senator.
Could you just clarify for me the previous recommendation? 1E, where the transaction in which a person pledges property to a pawnbroker, that it would not apply there?
All right. So it indicates that this part does not apply to interest of a buyer of accounts. Okay. A transaction in which a person pledges property. Right. So the property that you pledge to the pawnbroker, they would be already in that person's possession. And the normal modus operandi is, if, for example, you said, hold this, in 6 months, I'm coming back, I'm coming to repay you. You do not come back within the 6 months, and that person can now dispose of the item and hold those proceeds to settle their debt. So you're not going to subject them to say you have to go to court to seek an order to dispose of the property. So there are certain transactions which, based on the nature of the transaction, the debt can be settled outside of a cumbersome process.
So is there a provision for whatever value that pawnbroker would dispose of? Let's say the time, I'm asking, because this happens in real life, that the value that is disposed of is significantly more or what is outstanding. What does the customer, is there any guarantee for the customer to be?
So one of the underpinnings of these transactions is that you have a security contract. So in the security contract, it would have certain terms and conditions in regard to, for example, disposal and things like that. Now, so in normal contract law terms, if the person signs that, with those terms set out there, normally they are going to be bound by it unless they can prove maybe duress, misrepresentation.
The reason I'm asking is because with the exemption, this protection does not cover that circumstance, if I'm correct.
So they would not, if it is in the instance of a pawnbroker, they are one of the transactions who can go ahead and realize the security to set off the debt. So it therefore means before you sign that security contract, you have to ensure that the terms of the contract, it is as you would, it's fair.
Okay. Okay, so it's on the onus of the consumer, of
the person making the pledge.
Right.
So,
okay. All right. Thank you.
35. Yes, it will be very important because persons have to understand that you'll be bound by whatever you sign, and that terms of this contract is key. So ensure that it So, but just to know though, in like several of the other jurisdictions under the Uniform Commercial Code in the US, they too have similar exemptions. And I do believe even under, though I don't speak as authoritatively about this latter one, but I do believe as well, even under the Model Secured Transactions Law, which is drafted by UNCITRAL, that it is a similar arrangement there. So as you say, we really will have to do a lot of public education. We'll continue to do. All right. For 35, what did you say about 35?
Continuing, no comments?
All right, so the next proposed amendment is in regard to Section 35, enforcement accounts receivables, financial instruments, or intangibles. And this is on page 25 of the basic/general matrix. So the proposal is to amend Section 35, 1A, subsection 1, paragraph A. And this proposes to address enforcement, accounts receivables, financial instruments, or intangibles. Therefore, the reference to account debtor in subsection 1 is appropriate, given that an account debtor is typically associated with intangible assets or financial instruments. The inclusion allows the secured creditor with a security interest in accounts receivable to sell one or more of the accounts receivables as an alternative to collecting the debt over time from the account debtor. So, for example, a secured creditor, He'd say a secured creditor had 10 accounts receivables from an account debtor. That secured creditor can go ahead, account debtor becomes delinquent, they can go ahead and sell 2 of the accounts receivables, for example, to set off their debt without doing anything further. So again, this provision here, it is allowing persons to realize on their security where there has been a circumstance of default or an occasion of default, so to speak.
Next.
Section 37, obligation to give notice of disposition, and this is on page 29 of the basic/general matrix. So the proposal is to amend subsection 5 of section 37. And the reason that this is being proposed, the amendment is being proposed as specific rules that apply to intellectual property are required, since the method of ownership of intellectual property can vary. And as such, general disposal could not apply. So this amendment may encourage the acceptance of intellectual property as collateral. So, as we would well be aware, there are some cases in which the debtor may have a license to the intellectual property rather than ownership. And in that case, the most that they can give and the most that could be disposed of is the rights that occur through the license. So we make the distinction here in regard to the various forms that you can use intellectual property, and so we correlate the method of disposal with the right that you had to the intellectual property in the first place. So outright ownership, for example, against licensing.
Do we have a query? Yes. Ms. Grant.
The square, is it intended then for this part to be specific only to intellectual property licenses, or is it that you want a separate provision? Because 5 as it is now is broader and would capture other types of licenses. So if it is that you want a separate provision specific to intellectual property, then what we would do is keep this but insert a new 6.
So we would appreciate the latter, because what we want is a specific carve out for intellectual property.
Next.
The next proposed amendment is in regard to section 43 of the Act, and that is on page 31 of the basic/general matrix.
Page.
So
Page.
that page 31 of the matrix.
Okay.
So we're recommending that all references to real property be deleted. This section is addressing the applicability of the Act, where the security contract covers both real property and personal property. Oh. So this particular recommendation, sorry, we disagreed with this particular recommendation, so we would not accept that because the reading of the section as is really speaks to when you are dealing with a security interest in which the personal property relates to real property. So the recommendation would not be appropriate. So we did not accept this recommendation.
OPC, you have no issue with that. Moving along, please.
The next section for proposed amendments is section 48, and this is found on page 32 of the matrix. And this matter we kind of dealt with before. So it is amending section 48, subsection 3, paragraph C. The proposed amendment introduces searches by serial number of any property in light of the inclusion of the new definition for serial numbered property. In other words, the amendment seeks to include the serial number as a method used to search the register for any notice.
No comment, no questions, move on.
Next is the proposed amendment to section 49, and that is on page 33 of the matrix. So the proposed amendment here is to amend section 49, subsection 1, paragraph C. By the reason that the amendment is being proposed, by allowing the maximum of the principal indebtedness to be stated, this would facilitate the ease of doing business for customers by removing the need for frequent amendments to the registration notice. There are instances in which the amount of principal indebtedness changes frequently. Therefore, clarity is required on how this information is to be provided. So we will indicate, so there are some proponents who, for example, would have recommended that we totally remove any reference to indebtedness. Part of the reason put forward, as we're aware in commercial transactions, when someone creates a security interest, they oftentimes seek further disbursements. So you have an asset valued at 100 million. You took 40 million at first, and then 5 other times you go and you take 10, another 5, another 15. And so what we propose is what we consider a good middle ground where you state the maximum indebtedness. So on the registration notice, you don't have to put the exact amount that you're disbursing now. What you would be indicating that this security contract can cover up to the 100 million. So what this means is that a subsequent secured creditor would then go and do their due diligence and see what is the exact level of indebtedness. But it also means that they would be put on notice that this asset could be charged up to 100 million. And it means as well that the persons, they would not have to come back and file 5 different notices each time they disburse additional sums.
And a second creditor could do a sort of second mortgage.
They could, usually with the consent
With the consent of the first.
Of the first
creditor.
That's correct. And why we also choose to, despite the fact that other recommendations may have been made to say take out the maximum indebtedness, as we're aware, even in this forum, nationally and internationally, this data is required because we want to see, for example, how robust the regime is, who is getting loans, how much they are getting, etc. So, right. If there are no further comments.
No questions, no.
Thank you. So the next proposed amendment is in regard to section 50, and that is on page 34 of the matrix. So we are proposing to amend section 50, subsection 1. And the amendment would subject the provisions to section 52. And the reason that we've made this recommendation is because section 52 addresses the validity of a registration notice. So section 50 is speaking to sufficiency of identification, and we would tie that in to section 52, which speaks to the effects of defects or defects or irregularity. So it's basically showing you what is the effect. For example, if you didn't put the name properly, and so the section 50 indicates how you sufficiently identify someone. Section 52 indicates to what degree, if you made some sort of error, this can impact the notice, the validity of the notice.
Next.
All right, the next proposed amendment is in regard to section 51, and this is on page 35 of the matrix. And we're suggesting that the section be amended because the section currently allows
Section
51.
Section 51, okay. Yeah, see it?
So we're saying insert after section 57 and renumber the present subsection 8 as subsection 9. So we're making this proposal for amendment because currently the section allows the amendment of a notice by one secured creditor, which may prejudice the rights of other secured creditors. So the suggested amendment provides that only secured creditors who authorize the amendment notice will be bound by it. Provision promotes fairness when amending security interest notices. So the law allows the registration of a notice that involves more than one secured creditor. So if, for example, one secured creditor had an asset that they want to release, when they file that amended notice, what this provision does is that it ensures that if they are the only person who signs, then they are the only person who can be impacted. So for the other secured creditors' right to be prejudiced, they must also, in writing, sanction the amendment. Can move on.
Any comments about sanctioning the agreement? No comments, so move on, my dear.
All right. The next proposed amendment is in regard to section 52, and that is on page 35 of the matrix. So the proposal is to amend subsection.
That's 52.2?
It's, yes.
Section 52.2?
Section 52.2, that is correct,
okay.
Chair. And that is on page 35. of the matrix. So
yes, go ahead.
the suggested amendment indicates that the registration of a notice is invalid if a search of the register using essential information, such as the TRN, does not discover the registration notice. Note that where property cannot be searched and found by any of the criteria stated in Section 52, it causes another potential secured creditor to be unaware of the charged property and therefore any prior security interest. This amendment encourages due diligence during registration to avoid errors. It also supports the expansion of the Act regarding the use of serial numbered property. So basically, as is stated here, the law indicates that for anyone searching the registry, there are certain criteria or fields that they can use: the name, the TRN, now the serial number. So if the secured creditor who registered the notice made an error which would lead to a third party not finding that the security interests exist, then that notice is going to be invalid, because that person would have entered into a transaction with the debtor thinking that they have a certain priority, and that is due to the previous secured creditor's error, negligence. All right, if there are no comments.
You move along.
All right, the proposed amendment to Section 56, which is on page 37 of the matrix. This deals with refusal of registration. We're proposing to amend Section 56, subsection 1. The section currently provides that the registrar may refuse to register defective/irregular notice. This amendment removes this discretion by providing that the registrar shall not register such notices. And it really dovetails with what we said previously. It makes sense, because we just indicated that if, by virtue of the fact that you made an error in your entry, someone would not be able to find notice of that security interest, you are going to lose priority. So this corresponds with that, where it says the registrar shall refuse to register any defective or irregular notice, because the aim is that it's certainty. So any proposed secured creditor must be able to accurately assess the status of a security or of collateral.
Okay, moving right along.
All right, the next proposed amendment is in regard to Section 58, and that is on page 38 of the matrix.
38, you said?
Yes, Mr. Chair, page 38.
Yeah.
This deals with provision of information to the registrar. The section currently allows access to all information on registration notices.
We're looking at 58 or 59.7.
Section 58.
Okay, good.
So the section currently allows access to all information on registration notices, and amendment would seek to protect personal data. So for example...
One second, Mrs. Leon. Travel safely, teacher, and all your wonderful students. Good to see you and thank you for coming. Continue.
So here, we're taking into account the Data Protection Act. So for example...
Yeah, that's very important, very
yes.
important. Continue.
The next proposed amendment is in regard to section 62, and this is on page 39 of the matrix.
Yep.
So the amendment basically seeks to align the conflict of law provision set out at 62 with the UNCITRAL model law. The UNCITRAL model law. So they have a number of
Surely the children left just in time.
So in UNCITRAL rather, they have a number of model laws in regard to secure transaction, company law, other areas. And so what we're seeking to do here is to align this section 62 with that provision. We had previously received feedback, apart from our own local bar association and other legal persons. They had expressed a lack of satisfaction with this provision. They have pointed to certain concerns that they have, and so we're proposing that we adopt a provision similar to that contained in the UNCITRAL model law.
Go on, Mike, please. Thank you.
I was asking what that acronym means.
Oh, I don't remember now.
UNCITRAL, sound like a UN
We'll advise you.
But it's internationally based?
It is.
Okay.
Very well known,
Established.
widely utilized.
Right,
Yes.
okay. Thank you.
OPC and Google will tell you immediately.
Yes.
Citral. It's a term that
So
is
it's the
known.
United Nations Commission on International Trade Law.
Absolutely. Yeah.
Yes.
Thank you. Go ahead, please.
All right, so the next set of recommendations that we propose to look at is that for the Jamaica Bankers Association, and that starts on page 10 of
Page 10.
Yes, Mr. Chair,
So we
page
start
10.
We start back at the beginning.
Yes.
Okay.
So in regard to section 2, there is a proposed amendment with respect to the definition of execution creditor. We recommend amending section reference to state section 32, subsection 2. So the definition for the term execution creditor has already been stated at section 32, subsection 2. Therefore, referencing the section is appropriate. This will make the provisions more clear.
OPC? No issue there?
Currently, the definition references section 32, which is the sounder drafting practice rather than to be specific to the subsection, because then if there are any amendments and which require renumbering, we would still be covered. So it's better to just refer to the section generally.
All right, so we are guided. All right, in regard to the definition of officer, there is no definition of the term in this act. The definition for officer could reference the one stated in the Companies Act, since the subsection refers only to corporations.
I think that's not quite the case, because this section, which is section 60, which is the only section that refers to officer, and it deals with service of documents, also talks about associations. So I don't think that the definition in the Companies Act would quite meet it because it's a general definition. It says officer in relation to a body corporate includes a director, manager, or secretary. So it includes, it doesn't really limit it specifically. And in the case of an association, you might need something a bit different. The section also applies to other entities, even though officer is only used in this case to in reference to companies or associations. So you'd have to consider who might be the appropriate officers in those cases, whether you want to specify particular categories or maybe officers at a certain level.
All right, so we will revisit this particular submission in light of what you've just said. So these submissions are the ones made by the Bankers Association, and we will revisit that particular matter. The next submission is in regard to Section 22, priority between security interest, and that is on page 21 of the matrix.
Yeah, man, it's work. Page 21.
Page 21, Mr. Chair.
Thank you.
So the recommendation is that Section 22(3) requires the registration of amendment and amendment notice. So an amendment notice is filed when there are changes or updates to an existing security interest registration. Requiring registration ensures that any modifications to the original notice are accurately recorded and accessible to interested parties. Further, when a secured party amends a registration, it may impact the right of other parties. Registering the amendment provides notice to the public and maintains the integrity of the register.
Comments? No comments? Move on.
Section 34, and this is on page 25 of the...
Yeah.
So the Bankers Association, they have suggested an amendment to the effect that debtor is in default be deleted and in its place occurrence of an event of default. The term debtor in default is too narrow, as it suggests that only a default by the debtor can give rise to enforcement action under a security contract. Using an occurrence of an event in default would give wider applicability. And this recommendation was accepted by MIIC and the COJ.
And OPC has no issue.
Right. The next proposed...
Would you need to define the circumstances or what would constitute an event in default? Would that be defined determined by the contract, for example?
I would want to say the contract. It would be, because since there are a wide number of circumstances that a secured creditor may want to deem a certain set of acts or activities as an occurrence of an event in default. So we would prefer if the various security contracts indicate what constitutes an occurrence of an event in default. All right. The next proposed amendment is in regard to Section 37, which is on page 29 of the matrix.
'29 you said, right?
Yes, Mr. Chair, page 29. So the proposed amendment is to section 37, subsection 2, paragraph B. So this allows for greater efficiency. So a provision would be included to allow for the method of calculation to be given by the secured creditor. So the section seems to require that the notice state the amount that will be owing on a specified day. So there may be cases when it will not be possible to say in advance exactly what the amount will be on that future date. So the proposal is to amend the section to allow the secured party to explain how the amount is to be calculated if it cannot be identified as a fixed sum. So a provision would therefore be included to allow for the method of calculation to be given by the secured creditor. If there are no comments in regard to that proposed amendment.
Keep going.
The next proposal is in regard to section 38, which is on page 30 of the matrix. And this is dealing with surplus or deficiency on disposition. So we are proposing that an amendment be made to section 38, subsection 2. The rationale for that, a comprehensive account may be required so that the interested parties can adequately assess the state of affairs, whether the collateral is disposed of as a whole or partially. This one we disagreed with. So the suggested amendment may hinder accuracy, transparency, and risk management. Limiting the number of requests to twice a year might have adverse legal impact on persons stated at section 38(1). For example, a person with an interest on the surplus. Not placing a cap on the frequency of requests ensures that different stakeholders or parties can have access to relevant information. So what it is, the Bankers Association, they were proposing that persons can only request the status of the account twice per year. As is, there was no such limitation in the section, but what the section did do is provide a period of time that would be given basically for the request to be met. So we think that, which is 30 days, we think this is adequate and that you should not disenfranchise persons from being able to ask for an account. So we did not agree with this submission for amendment.
Okay. Move on. No comments?
The next proposed amendment is in regard to section 46, dealing with receivers, and this is on page 31 of the matrix. So the proposal was in two parts, and we'll state the portion that we agreed with and the portion that we disagreed with. So section 46(7), the proposal, and this was agreed, is that there be the inclusion of a definition, there be the inclusion of a prescribed fee to avoid arbitrary or exorbitant amounts being charged by the receiver. So we agreed with that proposal.
requires the fee to be prescribed, so it's the minister who would be making regulations specifying perhaps a maximum amount. So I'm not quite sure what a definition would add to that, because it would be specified.
All right, so I think maybe what they wanted was that, for example, a fee be stated and then from time to time, like with the other provisions, that it be changed as maybe situation, as time warrants. I think maybe that is what they wanted. But we're guided because, as you indicate, it would be more flexible to have the minister simply prescribe and change the fee rather than put something in the act, which will require a legislative amendment for that to be changed. So we accept. And then, yes, she's saying yes. And then the other submission, it was submitted that it should be stated that the Insolvency Act would take precedence in all matters relating to a receiver. And we did not agree that the Insolvency Act that we should state that the Insolvency Act would take precedence in all matters where there's a receiver. There are circumstances where a security contract may provide for the appointment of a receiver to come in, for example, and ensure that debts are repaid, even though the company may not be insolvent, but perhaps they may have defaulted on their payments. And so we disagreed that it should be stated that in all cases involving a receiver, the Insolvency Act should take precedence.
No comments? Move on. How much more we have to go?
We have a bit more, Minister.
How much?
About 5 other submissions. So we have some general comments and we have some further specific comments.
10, 15 minutes?
No, it would take longer than that, Minister.
All right. It looks like I'm being indicated that we should have a second session to complete this. If there are no other comments on what has just been said, do you have any wrap-up comments today? And then we set another meeting to complete this.
We don't have any further comments at this time, Chair.
Yes. And no other comments. I'm going to ask Senator Longmore if she'd move for the termination of today's meeting. Senator Longmore has moved, and I'm asking a member.
Seconded, Chair.
Okay.
Chair, just a quick...
That's Senator Golden Campbell.
Yes,
Yes, sir.
Just a quick administration note. The matrices being so important for the colleagues who are not here, perhaps the clerk or the office could see to them getting distributed at the various meetings, maybe tomorrow at Senate, for the senators who are not here and then in the other place.
Oh,
Yes.
you mean they now have soft copy, you want for them to
The
have
hard copies, because the hard copies are quite useful.
The hard copies are very useful.
Yes.
I mark upon them.
So I was going to take for the senators, but maybe we could just ensure that
The
they're
clerk,
available tomorrow.
I'm sure will arrange for them
Yeah.
to get in their boxes.
Thank you.
That's a good suggestion. The motion has been moved and seconded, and so all that's left for me to do is say thank you very much for coming, and a new meeting will be set as soon as we can, Mrs. Sutherland Reed and the clerk, to let us get to the end of this because we're close to it. Thank you so much, Ms. Leon, for leading us through today's discussion. OPC, as usual, thank you. Good.
Thank you, Chair. Thank you, colleagues.